So at Strongest Defense, we get a lot of calls about people who've been in trouble, arrested for drug sales, possession for sales, or transportation. The common term you might hear is drug trafficking, but in California, there's actually three separate offenses. We're not talking about marijuana because we made that lawful more or less a couple years ago. We're talking about heroin, methamphetamine, cocaine, and the big boy right now is fentanyl. Prescription drugs plays a part of it, but those are the main categories of drugs. In general, the ones that are opiates, the ones that make us sleepy or tired, like heroin or um, fentanyl or some prescription pills, those have a more serious sentencing range. But either way, we're talking about possession for sale. Usually, the police officer will tell us that you had so much of the drug, or maybe you had scales or baggies or something else, that you couldn't have possibly possessed the drug for personal use. It's actually for sale. When we're talking about methamphetamine, cocaine, and other stimulants, they're talking about a person not being able to consume that much of the drug without having a heart attack or something else occurring. So that's how they say possession for sale. With an actual sale case, they have to have you, generally speaking, actually sell a drug to another person, and they have to be able to test the drug you sold. And so that's what sales is about. Usually, they don't like to charge you with that because it involves them giving away their confidential informant that they don't want to do. The final category is transportation. Transportation sounds kind of like it should. It's moving drugs from one place to another, typically in a car. However, in California, there's even a law that says that you can be charged with transportation of a drug if you're walking the drug along the street. Now, if you're charged with transportation of a controlled substance in California, you want to contact us. If you're charged with possession for sale or any other kind of serious drug offense, they're felony charges. You face a serious time, so make sure you give us a call. So, drug sales in California have different penalties. The most serious of a drug sale or drug trafficking offense is actually when you use a person under the age of 18 to help you sell drugs. That's a mandatory state prison offense. You don't want to use kids for sure, and you don't want to get convicted of using kids in your drug sales if that's what they're trying to say you're doing. On the other hand, if you sell to a person under the age of 18, that's also a very serious crime that ends in state prison. You might think I would never sell to a child under the age of 18, but it can be used sometimes by aggressive law enforcement or overcharged, I might say. If you give something to a kid or have something on the table or it's accessible to the child, there are other charges that can go with that. In general, for a basic charge, possession for sale or sales or transportation of a controlled substance, you can get probation and 1 day to 365 days in jail, or for more serious offenses, or if you have prior convictions, the penalty can be anywhere from 16 months all the way up to 5 years. Also, if you have a gun while possessing drugs for sale, that could add 3 to 5 years to your sentence. Uh, Possessing a gun, by the way, doesn't necessarily mean that the gun and the drugs are together. It could mean the gun is in one part of the house and the drugs are somewhere else. So when you're faced with drug trafficking charge like possession for sale or transportation, one of the key ways to fight the charge is to help the court or the DA's office or in a jury trial uh, decide that your client actually uses the drugs that they possess. They're not for sales. The police officers will say silly numbers about how little you can use in a given day versus what we know actual consumers of this drug can go through. I personally help clients who've gone through an 8 ball a day of cocaine. Many law enforcement officers will tell you that would kill the person. I've been doing this for a long time. I've seen many drug cases, and that is one of the best ways to fight a possession for sale charge is to convince the jury or the judge or the DA that the drugs were for personal use. We have an expert on board, John, who's worked with me for decades now. And John has been an expert in this field for more time than I've done him, actually, 35 years. John helps us to navigate these waters and make sure that the jury knows from his expertise that a person could use this. Also, other defenses to drug crimes in general are police often use law enforcement confidential informants, and these confidential informants are usually drug users who then turn to help the police. Because they're drug users and because they're not necessarily required to stop using drugs by the law enforcement people, they use them again. If they get rearrested, then the confidential informant's information can be thrown out of court. When that happens, your case gets thrown out with them. Additionally, if the confidential informant was at the house or the car or the place of business where they found the drugs during a search, depending on how close in time the confidential informant was there, that's another reason we can get the case dismissed or the charges reduced. There are many other things you can look at to try and defend yourself with a drug trafficking charge. You shouldn't go through it alone. Give us a call and we'll see what your options are. In Ventura County, there are many cases that happen that get filed at the state level, and the consequences for a drug trafficking or drug sales charge in California are dramatically smaller or shorter in time than federal charges. In general, the feds don't get involved unless the weight of the drugs is very substantial, usually more than 10 pounds. I personally handled cases with over 40 pounds of drugs in state court, so the weight doesn't necessarily determine whether it would be a federal or a state crime. In general, the police officers who arrest you will try their best to make the penalty the worst, and if they think they can get some kind of federal prosecution for the drugs, they'll go that route and attempt to get you the higher penalty. Our job will be to try and make sure that doesn't happen and to do everything possible to make sure the feds don't want to touch it. In general, the federal government doesn't like a drug case unless it's got a big fat bow on it. There's a video, there's audio, and a confession. So that's the good news. They're really picky about the cases they take. If you've been arrested and you're not sure whether they're going to go with a state prosecution or a federal prosecution, please give us a call. We can actually help that process. I personally called the DA's offices before charges were filed in an attempt to get them to alter the charges or to make sure they stay at the state level. If you have been arrested for possession for sale or sales or transportation of a controlled substance, one of the things that we commonly see is that many people accused of that crime actually use the drug that they're accused of selling. And so the best way to improve the outcome on your case often is to seek drug treatment. Because if we can show the court that your sales or possession for sales were because you were an addict yourself, and we can show the court that you're now taking great steps towards cleaning your life up and becoming sober, we can often alter the outcome dramatically in your favor. And so if you've been arrested for that kind of crime, give us a call and see if we can help you find the proper drug treatment program or other methods we can use to lower the penalty.